Before we begin, a quick and important disclaimer. The following documentary explores the historical evolution and structural role of divorce attorneys within the United States legal system. This content is designed strictly for educational, historical, and entertainment purposes. It does not, under any circumstances, constitute formal legal advice, representation, or counsel. Family law is highly complex, constantly evolving, and varies drastically from state to state. The historical trends, case studies, and potential outcomes discussed in this video are meant to analyze the past and provide context for the present, not to guide personal legal decisions. If you are currently facing a domestic relations issue, separation, or dissolution of marriage, it is imperative that you conduct your own due diligence and consult with a licensed, practicing attorney in your specific jurisdiction. Do not use the historical accounts or legal theories presented here as a substitute for professional legal representation. In 1643, in the strictly Puritan Massachusetts Bay Colony, a woman named Dennis Clark did something that was virtually unthinkable in the Western world at that time. She stood before the Quarter Court of Assistants and demanded the legal dissolution of her marriage. Her husband had abandoned her for another woman, leaving her destitute. In a society where marriage was viewed as an unbreakable religious covenant, a sacred bond dictated by divine doctrine rather than civil contract, the colonial court actually granted her request. This event marked the first recorded legal divorce in the history of the American colonies. But here is the most structurally significant and shocking part of this historical milestone. She did not have a divorce attorney. The concept of specialized legal counsel for domestic dissolution simply did not exist. To understand the violent cultural and legal shift from a Puritan courtroom to the towering multi-billion-dollar family law firms of modern Manhattan and Los Angeles, we must first examine the suffocating legal framework that early Americans inherited from England. For centuries, the American legal system operated under the strictures of English common law, specifically a deeply entrenched doctrine that made the very concept of a divorce attorney an institutional impossibility. This doctrine was known as coverture. Under the legal fiction of coverture, upon marriage, a woman's legal rights and obligations were entirely subsumed by those of her husband. In the eyes of the law, the husband and wife became one single legal entity, and that entity was the husband. A married woman could not own property, sign contracts, retain her own wages, or enter into legal agreements independently. Therefore, the very idea of a wife hiring legal counsel to sue her husband for divorce was a legal paradox. The courts asked a simple, restrictive question: how could one legal entity sue itself? Because of this foundational legal architecture, obtaining a divorce in the United States for the next 2 centuries was a grueling, highly stigmatized, and practically inaccessible process. In many early jurisdictions, the courts had no power to grant a divorce at all. It required a literal act of the state legislature. To secure a dissolution, a citizen had to petition lawmakers directly and prove extreme, devastating fault, such as unrepentant adultery, extreme physical cruelty, or total, prolonged abandonment. Because the burden of proof was impossibly high and the social ruin so severe, a dark and fascinating legal subculture began to emerge out of necessity. The earliest iterations of the American divorce attorney were not the polished, highly respected litigators we see today. They were often viewed with intense societal suspicion, operating on the absolute fringes of the legal profession. They were the architects of necessary fictions. By the late 19th and early 20th centuries, the strict fault-based system gave rise to rampant perjury, staged hotel room affairs, and collusive legal strategies designed specifically to trick the courts into granting a dissolution. The divorce attorney of the 1920s and 1930s often had to act as a private investigator, a scriptwriter for staged infidelities, and a legal loophole expert just to help clients escape abusive, dangerous, or fundamentally broken marriages. In this documentary series, we will look at specific historical case studies where lawyers actively hired actors to be discovered by hired photographers in compromising positions, all to satisfy the rigid legal requirements of the era. The system was broken, hypocritical, and inherently corrupt, and the attorneys of the time were forced to navigate this deep moral gray area to achieve results for their clients. This historical pressure cooker eventually exploded in 1969, when Governor Ronald Reagan of California signed the nation's first no-fault divorce bill into law, fundamentally and permanently altering the fabric of the American family and birthing the modern family law industry as we know it today. Why does this history matter to you sitting here right now? Why should an American audience care about the shadowed history of legislative divorce or the staged, collusive hotel room photographs of the early 20th century? The answer is absolutely crucial for anyone who wants to understand the mechanics of power, wealth transfer, and family dynamics in modern America. We are going to decode the DNA of the American divorce attorney, tracing their evolution from legal pariahs to some of the most powerful and feared negotiators in the country. By understanding the historical origins of family law, you will uncover exactly why the modern legal system operates the way it does. The labyrinthine rules regarding alimony, the contentious battles over asset division, the concept of equitable distribution versus community property. None of these appeared out of thin air. They are the direct result of centuries of legal warfare, societal shifts, and the relentless advocacy of attorneys pushing the boundaries of the law to protect individual clients against a rigid system. This documentary masterclass promises to pull back the curtain on an industry that thrives behind closed doors and sealed court records. It solves the profound problem of legal illiteracy surrounding one of the most common, yet least understood, contractual dissolutions in civil society. We will examine historical trends that dictate how wealth is systematically divided today. We will track how child custody paradigms have violently shifted from the absolute property rights of the father under English common law, to the maternal preference of the tender years doctrine, and finally to the modern highly litigated standard of the best interests of the child. We will break down landmark case studies that redefine the very legal definitions of property, including how intangible assets like professional medical degrees, law licenses, and future earning capacities became massive battlegrounds for elite legal teams. If you have ever wondered why the legal process of unwinding a marriage is so notoriously expensive, emotionally taxing, and structurally complex, the answer lies hidden in the past. This series will equip you with a deep, uncompromising understanding of the legal machinery. Whether you are studying law, fascinated by American history, or simply want to understand the invisible forces that govern the institution of marriage and its dissolution, you are about to receive a comprehensive education in the evolution of legal strategy. We will expose how the legal profession adapted to, and often drove, the changing moral landscape of the United States. You will see how attorneys navigated the transition from an era where divorce was a public scandal requiring proof of grave sin, to an era of administrative dissolution where marriages can be ended citing irreconcilable differences. The divorce attorney has historically been a lightning rod for societal anxieties about the breakdown of the family, vilified as homewreckers and simultaneously celebrated as emancipators. The truth is far more complex. They are the essential technicians of a society that prizes individual liberty, but still struggles with the economic fallout of severed partnerships. To navigate the present, you must first master the history of how this legal arena was built. In the decades immediately following the American Revolution, the legal arena of divorce was almost entirely devoid of courtrooms, judges, and traditional litigation. To comprehend the monumental shift that occurred, we must first look at the bizarre and highly political mechanism of the legislative divorce. During the late 18th and early 19th centuries, if a citizen wanted to dissolve their marriage, they could not simply file a grievance at their local county courthouse. Instead, they were required to petition their state legislature. A divorce was not a judicial decree. It was a private bill, literally a new law passed by politicians specifically to sever the marital contract of two specific individuals. In this paradigm, the earliest American divorce attorney did not act as a litigator, but rather as a highly specialized political lobbyist. Their job was not to interpret statutes, but to persuade lawmakers that their clients' suffering warranted legislative intervention. Imagine if you are a woman named Sarah living in the United States, seeking a divorce. Today, in the year 2026, you would likely retain counsel, file a petition for dissolution online in your local jurisdiction, and proceed through a heavily standardized administrative and judicial process. But if you were Sarah living in 1815, your attorney faced an agonizingly complex and public ordeal. Step 1 required your lawyer to draft an exhaustive, highly dramatic petition detailing every instance of your spouse's cruelty, abandonment, or adultery. The language had to be sensational enough to capture the attention of busy politicians. Step 2 involved publishing notices of your intent to divorce in local newspapers for weeks on end, ensuring the maximum amount of public humiliation and community scrutiny. Step 3 required your attorney to physically travel to the state capitol, navigating the chaotic halls of the legislature to lobby state senators and representatives. Your lawyer had to call character witnesses to testify before legislative committees, essentially putting your deepest marital trauma on trial before politicians who were simultaneously debating tax policies and infrastructure. The process was astronomically expensive, completely public, and painfully slow, taking years to resolve. Consequently, this system heavily favored the wealthy and the well-connected, while the average citizen was trapped in the legal purgatory of a broken marriage. As the population of the United States exploded throughout the mid-19th century, state legislatures became hopelessly paralyzed by the sheer volume of these private divorce petitions. Lawmakers eventually rebelled against the workload, systematically transferring the power to grant divorces away from the state capitals and into the local judiciary. This structural pivot, birthing the judicial divorce, fundamentally redefined the role of the divorce attorney. They transitioned from political lobbyists into adversarial litigators. However, the laws they were forced to navigate remained exceptionally draconian. The courts operated strictly on a fault-based system. To obtain a divorce, an attorney had to definitively prove that one party was the innocent victim and the other was the guilty transgressor. There was no concept of mutual incompatibility or simply growing apart. The legal framework demanded a villain. This stringent demand for fault directly birthed one of the most controversial and highly stigmatized eras in the history of the American legal profession. Because elite corporate attorneys and high society litigators refused to associate themselves with the scandalous, deeply personal realities of domestic disputes, the early divorce attorney was often relegated to the shadows of the legal community. They were viewed with intense suspicion, labeled as opportunists who dealt exclusively in the moral decay of society. Yet, these attorneys were highly sought after because they possessed the tactical skills necessary to navigate a deeply hypocritical legal system. If a couple mutually agreed that their marriage was over but neither had committed a legally recognized offense like extreme physical cruelty or adultery, they were legally trapped. To solve this, attorneys began orchestrating elaborate legal fictions. We can observe this through historical trends and highly documented case studies of the era, particularly in jurisdictions with the most restrictive laws. For decades, the state of New York recognized only one single ground for divorce: absolute adultery. If an attorney was retained by a couple desperate to separate amicably in New York during the late 19th or early 20th century, they had to engineer a crime. The attorney would systematically map out a collusive strategy. Step 1 involved the husband traveling to a specific, prearranged hotel. Step 2 required the attorney to hire a female accomplice, whose only job was to be present in the hotel room wearing a nightgown. Step 3 was the critical execution of the trap. The attorney would hire a private investigator or a photographer to forcefully knock on the hotel room door at a precise time, documenting the staged scene. Step 4 brought the charade into the courtroom, where the attorney would present the investigator's testimony and the staged photographs as undeniable evidence of adultery. The judges, the clerks, and the attorneys usually knew exactly what was happening. It was an open secret, a synchronized theatrical performance designed to satisfy the rigid, unyielding demands of the fault-based legal framework. The divorce attorney became a master director of these legal illusions, forced to subvert the spirit of the law in order to fulfill the desperate needs of their clients. They operated in a perpetual state of ethical ambiguity, risking disbarment to provide a service that society demanded, but the legislature refused to modernize. This widespread reliance on perjury and fabricated evidence highlighted the utter failure of the fault-based system, yet it persisted for decades, deeply ingraining a culture of extreme adversarial hostility into the DNA of family law. The requirement to aggressively attack the opposing party, to dig up dirt and expose secrets, became the foundational strategy of the American divorce attorney, a legacy that still casts a long shadow over modern proceedings today. But as the 20th century progressed and the cultural appetite for divorce began to accelerate, the wealthy elite of the United States grew tired of staging embarrassing hotel room affairs or waiting years for restrictive local courts to grant them their freedom. They demanded a faster, cleaner, and more efficient exit strategy. American attorneys, recognizing this lucrative demand, began searching for a legal workaround. They found their answer not in family court, but deeply embedded in the text of the United States Constitution itself. By exploiting a massive jurisdictional loophole, a small group of visionary and highly opportunistic lawyers transformed a dusty, isolated railway town into the uncontested divorce capital of the world, sparking a nationwide legal war over state sovereignty and the true definition of residency. The legal workaround that birthed the migratory divorce industry relied entirely on a foundational piece of American jurisprudence known as the Full Faith and Credit Clause, located in Article 4 of the United States Constitution. This clause mandates that every state must respect the public acts, records, and judicial proceedings of every other state. A group of highly strategic attorneys realized that if they could successfully obtain a valid divorce decree for a client in a state with extremely lenient laws, the client's home state, no matter how restrictive or conservative its own laws were, would be constitutionally forced to recognize that divorce as legally binding. This brilliant but deeply controversial interpretation of constitutional law initiated a massive geographic shift in family law litigation. Attorneys stopped trying to fight the unwinnable battles in places like New York or South Carolina, where the laws were rigidly opposed to dissolution, and instead began directing their wealthiest clients to board trains heading straight for the American West. The epicenter of this legal revolution became the state of Nevada, and specifically the city of Reno. Recognizing a massive economic opportunity during the ravages of the Great Depression, Nevada legislators aggressively weaponized their state sovereignty to attract out-of-state wealth. In 1931, the Nevada legislature passed a radical law dropping the state residency requirement for obtaining a divorce to a mere 6 weeks. Furthermore, Nevada allowed for divorce on the grounds of extreme mental cruelty, a highly subjective standard that local Reno judges interpreted with maximum leniency. Practically overnight, the role of the Reno divorce attorney transformed into a high-volume, highly lucrative logistical operation. These local attorneys formed tight networks with hotel owners, train operators, and the owners of newly established dude ranches, creating a fully integrated hospitality and legal pipeline designed to process human heartbreak on an industrial scale. Let us examine an imagine-if scenario to fully grasp the mechanics of this historical trend. Imagine a wealthy socialite named Evelyn living in an aggressively restrictive jurisdiction. If Evelyn were seeking to dissolve her marriage today in the year 2026, her legal counsel would navigate a heavily standardized, no-fault administrative system locally. But in 1932, Evelyn had to engage in a practice known as migratory divorce. Step 1 of this highly orchestrated legal strategy required her local attorney to quietly refer her to a specialized counterpart in Reno. Step 2 required Evelyn to pack her bags, board a transcontinental train, and physically relocate to Nevada. Step 3 involved her moving into a specialized dude ranch, where she would spend exactly 42 days riding horses, socializing, and spending money in the local economy to satisfy the strict 6-week residency mandate. Step 4 was the execution of the legal maneuver. On the 43rd day, Evelyn would meet her Reno attorney at the Washoe County Courthouse. The attorney would present a perfunctory case alleging vague mental cruelty. A local witness would testify that Evelyn had indeed lived in the county for 6 weeks, and the judge would grant the decree in a hearing that routinely lasted less than 5 minutes. Step 5 saw Evelyn immediately boarding a train back home, clutching a legally binding document that completely nullified her marriage. This system was devastatingly efficient, but it fundamentally fractured the American legal landscape and placed attorneys directly in the crosshairs of a furious interstate legal war. The attorneys facilitating these migratory divorces were constantly walking a tightrope of legal peril. The conservative states losing their wealthy citizens to the Reno divorce machine began fighting back aggressively, instructing their own prosecutors and state judges to invalidate the Nevada decrees. They argued that these 6-week vacations did not constitute genuine legal domicile, meaning the Nevada courts lacked the actual jurisdiction to sever the marriages in the first place. The role of the divorce attorney suddenly escalated from processing paperwork in a local courthouse to defending the very constitutional validity of their clients' newly acquired single status. The structural tension eventually exploded onto the national stage, culminating in multiple landmark Supreme Court case studies, most notably the legal warfare surrounding Williams versus North Carolina in the 1940s. In this highly publicized historical event, a man and a woman left their respective spouses in North Carolina, traveled to Nevada, obtained 6-week migratory divorces, married each other in Nevada, and then returned to North Carolina. The state of North Carolina refused to recognize the Nevada divorces and promptly arrested the couple, prosecuting them for bigamous cohabitation. They were convicted and sentenced to hard labor. The attorneys representing this couple had to fight their way to the highest court in the land, sparking a bitter debate among Supreme Court justices over state sovereignty, the definition of domicile, and the absolute chaos that ensues when 50 different states have 50 different definitions of marriage and divorce. The Supreme Court issued highly fragmented and contradictory rulings over several years, initially stating that North Carolina had to respect the Nevada decrees, but later ruling that North Carolina had the right to question whether the couple had actually intended to remain in Nevada indefinitely, which is the true legal test for domicile. Because of these erratic rulings, Divorce attorneys across the country were forced to advise their clients that a migratory divorce was essentially a game of legal roulette. If an angry ex-spouse decided to challenge the validity of a Reno decree in a home state court, the client could face devastating financial consequences, loss of property rights, or even criminal prosecution for bigamy if they had remarried. The divorce attorney was no longer just a litigator. They had to act as a constitutional risk assessor, calculating the precise statistical likelihood that a foreign decree would hold up under aggressive interstate scrutiny. They had to navigate a landscape where a person could be legally divorced in one state, legally married in another, and a criminal bigamist in a third. This era of migratory divorce and staged hotel room adulteries exposed the absolute hypocrisy and structural failure of the American fault-based divorce system. Millions of Americans were demonstrating through their actions and their willingness to spend vast sums of money to travel across the country that they fundamentally rejected the idea that the state should force them to remain in broken marriages or require them to commit perjury to escape. Attorneys were exhausted by the ethical gymnastics required to practice family law. Judges were tired of the transparently manufactured evidence, and the public was rapidly shifting its moral perspective on the permanence of marriage. The pressure on the legislative framework was building to an unsustainable breaking point. The system was about to experience a catastrophic structural collapse, one that would completely eradicate centuries of common law tradition and force the divorce attorney to adapt to an entirely new universe of financial warfare. The catastrophic structural collapse arrived on September 4, 1969, fundamentally obliterating the fault-based foundation of American family law. On this day, California Governor Ronald Reagan signed the Family Law Act into effect, creating the first pure no-fault divorce system in the Western world. To understand the sheer magnitude of this historical trend, you must realize that prior to this exact moment, the state held an iron grip on the exit doors of marriage. The government demanded a culprit, but the 1969 legislation introduced a quiet, profoundly revolutionary phrase into the legal lexicon: irreconcilable differences. This two-word legal mechanism bypassed the need for staged adultery, manufactured cruelty, or exhaustive interstate travel. It declared that a marriage could be dissolved simply because the partnership had broken down beyond repair, requiring no assignment of moral blame. Imagine if a couple named Robert and Linda, living in the United States, decided their marriage was over. Today, in the year 2026, Robert and Linda would consult their respective legal counsel, draft a petition citing irreconcilable differences, and proceed into an administrative negotiation over assets and child custody. The modern court does not care why they are separating. The court only cares about how to equitably dismantle their shared economic life. But if Robert and Linda sought a divorce in California in 1968, just 1 year prior to the new legislation, their attorneys would be forced to litigate a brutal public trial assigning absolute guilt to one of them. The no-fault revolution instantly transformed the American divorce attorney from a moral adjudicator and private investigator into a highly specialized financial negotiator. Because the courts were no longer clogged with endless testimonies trying to prove who slept with whom, or who abandoned the marital home, the legal battlefield radically shifted. The central question was no longer whether a divorce would be granted, but rather, what would the economic reality of that dissolution look like? This paradigm shift triggered an entirely new universe of financial warfare, forcing the divorce attorney to completely rebuild their professional toolkit. Without the leverage of fault, the legal strategy pivoted exclusively to the valuation and division of marital assets. During the fault era, an innocent wife might leverage her husband's guilt to secure a massive alimony settlement or the entirety of the marital estate. Under the new no-fault system, that moral leverage evaporated overnight. As a direct result, historical trends from the 1970s reveal a devastating economic fallout, particularly for women who had spent decades as homemakers. They were suddenly walking out of courtrooms with a simple 50-50 split of tangible assets, but no long-term financial security, plunging many displaced homemakers into poverty. Recognizing this structural crisis, the most elite divorce attorneys realized they had to become aggressive forensic financial analysts. They could no longer rely on the drama of a broken heart. They had to master the deeply complex mathematics of broken corporations, hidden offshore accounts, and future tax liabilities. The attorney-client relationship underwent a profound psychological shift. Clients still walked into law offices demanding vengeance for infidelity or emotional neglect, but the attorney had to strictly re-educate them. The lawyer had to look the client in the eye and explain that the court no longer cared about their broken heart. The court only cared about their balance sheet. This required attorneys to adopt a highly clinical, deeply pragmatic approach, often acting as financial therapists to de-escalate emotional volatility and refocus the client on pure economic survival. This era birthed the modern discovery process in family law, a grueling procedural mechanism that attorneys used to unearth hidden wealth. Prior to no-fault divorce, attorneys spent their time looking for hotel receipts and eyewitnesses. After no fault, they began issuing subpoenas for corporate tax returns, demanding access to safety deposit boxes, and hiring forensic accountants to trace the flow of hidden capital through shell companies and complex trusts. The divorce attorney of the 1970s and 1980s had to become an expert in the Employee Retirement Income Security Act, understanding exactly how to draft a qualified domestic relations order to legally slice a pension plan in half without triggering massive federal tax penalties. They had to learn how to value a privately held family business, engaging in intense battles over the concept of goodwill and future projected earnings. The courtroom transformed into a boardroom, and the attorneys became the chief executive officers of their clients' financial dismantling. Let us look closely at the mechanics of this financial warfare through the lens of property division models. The United States is divided into two distinctly different legal universes when it comes to marital property: community property states and equitable distribution states. In a community property state, the law generally views marriage as a strict 50-50 economic partnership. Any wealth generated during the marriage, regardless of who earned the paycheck, is typically divided equally. However, in an equitable distribution state, the court has the vast discretionary power to divide assets in a manner it deems fair, which does not necessarily mean equal. The strategic role of the divorce attorney in an equitable distribution jurisdiction is an exercise in high-stakes persuasion. They must build a comprehensive case study of their client's entire life. Imagine if a client named John in 2026 sacrificed his own career progression to manage the household and raise 3 children, while his spouse built a multi-million-dollar medical practice. In an equitable distribution state, John's attorney would meticulously quantify those non-financial contributions. They would calculate the replacement value of childcare, household management, and the massive opportunity cost of John's lost career trajectory. The goal is to legally compel a judge to award John perhaps 60 or 70% of the liquid marital assets to offset the extreme disparity in future earning potential. This requires a level of economic modeling and courtroom storytelling that earlier generations of family lawyers never had to conceptualize. The transition into this purely financial battleground also caused a massive escalation in the cost of legal representation. Because the attorneys were now dealing with complex financial instruments, stock options, restricted stock units, and intricate tax codes, the hours required to prepare a case skyrocketed. The discovery phase alone could consume months or even years of billable hours. Attorneys deploy extensive legal tools known as interrogatories, which are formal, binding questions requiring sworn written answers regarding every penny earned or spent. They execute relentless requests for production of documents, legally forcing the opposing side to hand over terabytes of digital data, credit card statements spanning decades, and internal corporate ledgers. The modern divorce attorney became the general of a vast army of financial experts, deploying real estate appraisers, vocational evaluators to prove an unemployed spouse is actually capable of working, and forensic accountants to build an impenetrable fortress around their clients' assets, while actively trying to breach the financial defenses of the opposing side. The sheer volume of paperwork and financial data analyzed during a high-net-worth dissolution is staggering, often rivaling the complexity of a massive corporate merger or bankruptcy proceeding. Yet, as attorneys became increasingly sophisticated in their ability to locate and value physical assets like real estate, investment portfolios, and business holdings, they soon encountered a massive conceptual problem. What happens when the most valuable asset generated during a marriage is not a physical object, a bank account, or a piece of real estate? What happens when a couple spends 10 years and hundreds of thousands of dollars to put one spouse through a rigorous professional medical or legal program, and the exact moment the degree is awarded, the marriage ends? The non-student spouse is left with massive student loan debt and years of lost wages, while the student spouse walks away with a lifetime of massively increased earning capacity. As the late 20th century approached, attorneys realized that traditional definitions of property were entirely inadequate for the modern American economy. The next great legal war would not be fought over houses or bank accounts, but over the very human capital residing inside a person's mind, sparking one of the most intellectually violent and paradigm-shifting legal battles in the history of American jurisprudence. This intellectual battleground centered around a societal trend so prevalent in the mid to late 20th century that it actually earned its own deeply cynical colloquialism among family law practitioners, known as the putting hubby-through syndrome. To understand the monumental legal crisis this created, we must examine the typical historical trajectory of these specific marriages. In countless case studies from this era, a couple would marry young. One spouse, historically the wife, would immediately enter the workforce, often taking demanding but lower-paying jobs as a teacher, a nurse, or a clerical worker. She would use her entire income to pay for the couple's rent, groceries, and living expenses, while simultaneously taking on the entirety of the domestic labor. Her spouse, meanwhile, would dedicate all his time and energy to attending medical school, law school, or a highly specialized dental program. For 7 or 8 years, the marital unit operated with a single unified economic goal: acquiring that professional license. The massive problem arose the exact moment they on the diploma. Often, within months of passing the bar exam or securing a lucrative medical residency, the newly minted professional would file for divorce. When the spouses walked into the courtroom, the financial reality was stark and fundamentally unjust. Because all their income had been funneled into tuition and basic survival, there were no traditional assets to divide. There was no house, no stock portfolio, no retirement savings. The only tangible marital property might consist of a used car, some second-hand furniture, and perhaps a meager savings account. Under the rigid traditional definitions of property law, the wife who had sacrificed a decade of her own earning potential was entitled to exactly half of the used furniture. The husband, however, walked away with a piece of paper that guaranteed him millions of dollars in future enhanced earnings. Traditional property law defined an asset as something that possessed exchange value, something that could be sold on the open market, transferred, or inherited. A medical license cannot be sold to another person. It cannot be passed down to an heir. It is intrinsically tied to the individual mind of the holder. Therefore, conservative judges consistently ruled that a degree was simply not property, leaving the supporting spouse in a state of sudden, devastating economic ruin. This structural inequity forced the most innovative divorce attorneys of the era to become aggressive legal philosophers. They recognized that the entire concept of property had to be fundamentally redefined to protect their clients. This historical push culminated in one of the most famous case studies in American family law, the monumental litigation of O'Brien versus O'Brien in the state of New York. In this specific historical event, the couple was married for 9 years. During that entire time, the wife relinquished her own opportunity to obtain a permanent teaching certification, working instead in various temporary capacities to fully support her husband while he attended college and then medical school in Mexico. Just 2 months after he received his medical license to practice in New York, he filed for dissolution. The wife secured a fiercely brilliant attorney who decided to challenge centuries of established common law. The attorney argued that the medical license was not merely a personal achievement, but a joint economic investment, a piece of intangible marital property created through the shared sacrifice of the partnership. To prove this radical theory, the divorce attorney could no longer rely on standard legal precedents. They had to completely assimilate the fields of macroeconomics and actuarial science. The attorney had to hire specialized economic analysts to build a highly complex financial model to put a definitive price tag on human potential. This process required a grueling, step-by-step mathematical execution. Step 1 involved establishing the baseline. The attorney and their economists had to calculate exactly how much money the husband would have earned over his entire working life if he had only possessed a standard college degree. Step 2 required projecting his enhanced earning capacity. They analyzed extensive data from medical associations to determine the average lifetime earnings of a specialized, board-certified physician in his specific geographic area. Step 3 was the calculation of the differential, subtracting the baseline earnings from the projected physician earnings to isolate the specific financial value generated purely by the medical license. But the mathematical warfare did not stop there. Step 4 required the attorney to apply a massive discount rate, reducing those projected future millions into a present value sum that could actually be negotiated in the courtroom today. Step 5 involved factoring in the statistical probabilities of mortality, disability, and future tax liabilities over a 40-year career span. Finally, Step 6 required the attorney to legally map out a coverture fraction, an exact percentage that represented the wife's specific economic contribution to the acquisition of that asset. In the O'Brien case, the trial court agreed with this revolutionary strategy, valuing the medical license at nearly $500,000 in 1980s currency, and awarding the wife a significant percentage of its value. When the New York Court of Appeals ultimately upheld this decision, it sent a violent shockwave through the entire American legal system. Imagine if you are a citizen named David in the year 2026. You spend the first 8 years of your marriage working double shifts in a manufacturing plant to completely fund your spouse's pursuit of a highly specialized doctorate in artificial intelligence engineering. Just as your spouse accepts a massive partnership at a leading tech firm, the marriage dissolves. Depending entirely on the state in which your attorney files the petition, the potential outcomes of your entire financial future will vary wildly. Because of the historical fracturing caused by cases like O'Brien, the United States is currently a patchwork of contradictory laws regarding human capital. In states like New York, your attorney will aggressively value that degree as a divisible asset, potentially securing you a multi-million-dollar payout representing your share of her future earnings. However, in many other jurisdictions, courts eventually rejected the New York model, fearing that dividing future earnings amounted to a form of indentured servitude. In those states, your attorney must instead pivot to a strategy of reimbursement alimony, forcing the court to merely repay you for the actual out-of-pocket tuition costs and living expenses you contributed, fundamentally denying you any share of the massive wealth your sacrifice actually generated. This jurisdictional chaos elevated the role of the modern divorce attorney to a level of staggering complexity. They are no longer simply dissolving a civil contract. They are actively unwinding deeply intertwined, multi-million-dollar human corporations. They must cross-examine rival economic experts, attacking the opposing side's discount rates, inflation projections, and mortality tables with the precision of a Wall Street forensic auditor. The courtroom transforms into an exhaustive seminar on advanced financial modeling, where attorneys battle over the exact statistical likelihood of a surgeon developing arthritis or a corporate executive being subjected to a hostile takeover, all to accurately price the value of their future labor. By successfully commodifying human intelligence and future earning capacity, the elite divorce attorney effectively learned how to monetize time itself. They mastered the art of extracting massive wealth from the invisible, intangible assets of a severed partnership. But this relentless, highly clinical pursuit of maximum financial leverage eventually collided with a terrifying reality. While attorneys were busy calculating the present value of medical licenses and engineering degrees, treating human lives as entries on an actuarial spreadsheet, an entirely separate and vastly more volatile war was brewing in the hallways of the family court. They were about to enter an arena where financial models were utterly useless, where the currency was not future earnings or real estate, but human psychology, leading to the darkest, most emotionally destructive phase of American family law litigation. This arena is the battle for child custody. To understand how modern divorce attorneys navigate this deeply traumatic landscape, we must trace a historical pendulum that swung violently from one legal extreme to another over the course of 3 centuries. When the first American family law frameworks were established, the concept of custody as we understand it today simply did not exist. Under the strictures of English common law, which heavily influenced early American jurisprudence, a child was not viewed as a psychological entity requiring emotional nurturing. A child was viewed legally as a piece of property, an economic asset that belonged entirely and exclusively to the father. The early divorce attorney rarely litigated custody because there was nothing to litigate. The law operated under the doctrine of paternal preference. If a marriage dissolved, the father automatically retained custody of the children, regardless of his temperament, unless he was proven to be shockingly unfit. The mother had virtually no legal rights to her own offspring. The children were considered the physical and economic yield of the marital estate, and the father held the absolute title. As the United States transitioned into the Industrial Revolution, the economic structure of the family underwent a massive physical relocation. Fathers left the agrarian homesteads to work in factories and urban centers, while societal norms rapidly shifted to position the mother as the absolute center of the domestic sphere. This massive cultural realignment forced a complete restructuring of family law, birthing a new legal standard known as the tender years doctrine. This doctrine operated on the strict presumption that during a child's formative years, typically defined as birth to age 7 or sometimes older, the mother was uniquely and biologically suited to provide the necessary care. The pendulum swung completely to the opposite extreme. Under the tender years doctrine, the divorce attorney representing a father faced an almost insurmountable legal wall. Unless the attorney could definitively prove that the mother was morally bankrupt, heavily intoxicated, or severely abusive, the court would automatically award custody to the mother. The legal strategy during this era was entirely focused on moral character assassination. If a father wanted custody, his attorney had to deploy private investigators to unearth any hint of the mother's infidelity or societal indiscretion, weaponizing the strict moral codes of the era to prove her legally unfit. Imagine if a father named Michael living in the United States in the year 2026 decides to fight for primary custody of his 3-year-old daughter. Today, Michael and his legal counsel will enter a gender-neutral courtroom where the law explicitly forbids judges from making custody decisions based solely on the sex of the parent. His attorney will focus on his active parenting history, his emotional bond with the child, and his capacity to provide a stable environment. But if Michael had filed that exact same petition in 1950, his attorney would have told him that the case was virtually hopeless before they even filed the paperwork. The tender years presumption was so legally entrenched that fathers were routinely relegated to the role of weekend visitors, fundamentally severed from the daily lives of their children. This rigid maternal preference held a total monopoly over American family law until the late 20th century, when the cultural upheavals of the civil rights movement and the push for gender equality systematically dismantled it. State Supreme Courts and legislatures began striking down the tender years doctrine, ruling that assigning parental fitness based entirely on gender violated equal protection under the law. In its place, the legal system installed a new, beautifully sounding, yet structurally terrifying standard known as the best interests of the child. The transition to the best interest standard represented the most profound psychological shift in the history of the divorce attorney. The law suddenly demanded that judges look beyond biological sex and instead analyze the deeply subjective, highly complex emotional landscape of the family unit. The court was ordered to evaluate factors such as the emotional ties between the parent and child, the capacity of the parent to provide a safe home, the child's integration into their school and community, and the mental and physical health of all individuals involved. While this standard was created to protect the child, it inadvertently turned the modern family court into a psychological war zone. Because there were no longer any automatic presumptions of custody, every single aspect of a parent's life became weaponized litigation material. The modern divorce attorney was forced to pivot from arguing simple legal precedents to directing massive psychological evaluations. They became the producers of exhaustive character studies. When millions of dollars in child support and the fundamental right to raise a child are at stake, the gloves come off completely. Attorneys no longer fight these battles alone. They rely on an entire secondary industry of mental health professionals, guardian ad litems, and forensic custody evaluators. Let us break down the exact step-by-step mechanics of a modern, high-conflict custody evaluation, which demonstrates historical trends of increasing psychological intrusion. Step 1 begins when the attorney successfully petitions the court to appoint a forensic psychologist. This expert is granted terrifyingly broad access to the family. Step 2 involves exhaustive clinical interviews. The parents are subjected to grueling psychological testing, often taking the Minnesota Multiphasic Personality Inventory or the Rorschach Inkblot test, designed to unearth hidden pathologies, narcissism, or borderline personality traits. Step 3 requires the evaluator to observe the parents interacting with the children in a clinical setting, taking meticulous notes on body language, tone of voice, and emotional responsiveness. Step 4 is the collateral investigation. The attorney assists the evaluator in gathering a mountain of third-party data, subpoenaing pediatric medical records, interviewing school teachers, speaking with nannies, and demanding therapy notes from private counselors. Step 5 culminates in the evaluator drafting a massive, heavily detailed psychological report, often spanning dozens of pages, concluding with a strict recommendation to the judge regarding exactly how the child's time should be divided. In this brutal arena, the attorney must master the art of cross-examining mental health professionals. They must know how to attack the methodology of a psychological test, arguing that the normative data used to score a personality inventory does not apply to their specific client under the extreme stress of a divorce. They must understand highly complex, fiercely debated psychological theories, such as parental alienation. This occurs when one parent systematically manipulates the child to unjustly reject and fear the other parent. In a modern courtroom, an attorney representing an alienated parent must prove that the child's sudden hatred is not based on actual abuse, but on a campaign of psychological brainwashing. This requires presenting dense psychiatric testimony to convince a judge to take the extreme and terrifying measure of removing the child from the favored parent and placing them in a specialized reunification program. The financial and emotional toll of this psychological warfare is staggering. Families regularly bankrupt themselves paying for dueling expert witnesses, thousands of billable attorney hours, and endless court-mandated therapies. The best interest standard, while noble in its intent, created a system where attorneys are professionally obligated to exploit every human flaw, every momentary lapse in parenting judgment, and every private psychological struggle of the opposing party. The courtroom becomes a theater of trauma, where children are placed under the microscopic scrutiny of state-appointed strangers, and parents are forced to publicly tear each other apart to prove their own fitness. The sheer devastation caused by this hyper-adversarial approach to human relationships eventually led the most forward-thinking legal minds to realize that the courtroom itself was fundamentally toxic for families. This realization sparked a desperate search for an alternative, driving the evolution of the American divorce attorney out of the public courthouse and into a highly secretive, privatized system of shadow justice that operates behind firmly locked doors. The public courthouse fundamentally is a massive vulnerability. In the United States, civil court proceedings and the documents filed within them are a matter of public record. For decades, the traditional divorce attorney functioned as a gladiator in this completely transparent arena. Whenever an attorney filed a financial affidavit, a deeply personal psychological evaluation, or a business valuation report, that document became accessible to journalists, business competitors, and inquisitive neighbors. As the economic stakes of dissolution skyrocketed in the late 20th century, particularly for high-net-worth individuals, business owners, and public figures, attorneys recognized a critical systemic flaw. A public trial could obliterate a client's corporate valuation, expose proprietary trade secrets, and permanently damage their public reputation. To solve this existential threat, the elite legal community engineered a complete paradigm shift, steering the most complex domestic disputes away from the gavel of a state-appointed judge and into the discreet, highly controlled realm of alternative dispute resolution. This structural migration effectively birthed a parallel legal universe. The modern divorce attorney was no longer just a courtroom litigator. They had to master the nuanced, entirely distinct architectures of mediation and private arbitration. To understand the mechanics of this shadow justice, we must break down the exact step-by-step processes of these two dominant historical trends. Mediation is the most common form of alternative dispute resolution. In this scenario, the attorneys do not present evidence to a judge to demand a ruling. Instead, both parties and their respective legal counsel convene with a neutral third-party mediator, often a highly experienced former family law attorney or a retired judge. The mediator has absolutely no power to force a decision or issue a legally binding order. Their sole purpose is to facilitate complex negotiations, traveling back and forth between separate conference rooms, utilizing psychological de-escalation techniques and financial modeling to help the parties reach a voluntary settlement. If mediation represents a guided negotiation, private arbitration represents the absolute privatization of the judicial power itself. In an arbitration setting, the parties essentially rent a private judge. They hire a highly specialized arbitrator, sign a legally binding contract agreeing to abide by their decision, and conduct a full trial entirely behind closed doors. The rules of evidence might still apply, the attorneys still conduct aggressive cross-examinations, and financial experts are still called to testify, but it all happens in a private boardroom. The public has zero access. The media cannot request transcripts. The final ruling is quietly filed with the local court to finalize the dissolution, but the intricate details of the wealth transfer and the specific allegations raised during the proceedings remain permanently sealed under strict non-disclosure agreements. Let us explore an imagine-if scenario to demonstrate exactly how crucial this private infrastructure is today. Imagine if a tech entrepreneur named Elizabeth, living in the United States in the year 2026, is preparing to take her artificial intelligence software company public in a highly anticipated initial public offering. Simultaneously, her marriage collapses. If Elizabeth's attorney files for a traditional public litigated divorce, the opposing counsel will immediately issue subpoenas demanding total access to her company's internal financial projections, proprietary algorithms, and unreleased product roadmaps to accurately value the marital estate. Because these documents would be entered into the public record, Elizabeth's competitors could legally access them. Her investors, terrified by the instability and the exposure of sensitive data, might pull their funding, causing the valuation of the company to plummet by hundreds of millions of dollars before the initial public offering even occurs. To prevent this catastrophic financial outcome, Elizabeth's attorney must immediately deploy a strategy of absolute containment. Step 1 is executing a tolling agreement, temporarily pausing any aggressive litigation deadlines to keep the dispute out of the public docket. Step 2 involves drafting an exhaustive confidentiality agreement that binds the opposing spouse, their attorneys, and all financial experts to strict secrecy. Step 3 is moving the entire valuation and division process into a private arbitration suite. In this controlled environment, Elizabeth's attorney can present the necessary financial data to the private arbitrator without risking corporate exposure. The divorce attorney in this scenario is acting less like a traditional family lawyer and more like a high-stakes corporate risk manager, utilizing the architecture of private justice to protect the client's overarching economic empire. This massive shift toward privatization also gave rise to an entirely new philosophy of legal representation, known as the collaborative law movement. This historical trend emerged in the 1990s as a direct rebellion against the psychological destruction of the courtroom. In a collaborative divorce, the attorneys require their clients to sign a binding participation agreement. This contract explicitly states that the attorneys are retained solely to negotiate a settlement, and if the negotiation fails and either party decides to litigate in court, both attorneys are legally disqualified from representing them. They must resign. This creates a massive financial and procedural incentive for everyone at the table to find a compromise, as walking away means starting the entire expensive legal process over with new counsel. The collaborative divorce attorney functions as part of a specialized interdisciplinary team, bringing in neutral financial professionals to objectively value assets and neutral mental health professionals to draft parenting plans, effectively stripping the adversarial weaponry out of the process. Through mediation, private arbitration, and collaborative law, the modern divorce attorney successfully engineered an escape hatch from the brutal transparency of the public legal system. They created a highly efficient, sterilized environment where massive fortunes can be divided and complex custody arrangements can be negotiated without the trauma of a public trial. The traditional image of the divorce lawyer screaming objections in a crowded courtroom has been largely replaced by the reality of attorneys sitting in mahogany conference rooms, silently passing spreadsheets back and forth. However, this transition into the shadows, while protecting the privacy of the elite, inadvertently created an entirely new and far more dangerous legal environment. When you remove the scrutiny of the public docket and the watchful eye of a state judge, you create the perfect ecosystem for profound financial deception. By moving the division of wealth behind firmly locked doors, the system relied heavily on the absolute honesty of the parties involved to accurately disclose their assets. But human nature, especially when faced with the division of a life-altering fortune, is rarely completely honest. The privatization of family law paved the way for the most sophisticated era of hidden wealth in American history. Attorneys soon discovered that while they were negotiating in those private conference rooms, entire empires of marital capital were being quietly funneled out of the country, buried in offshore trusts, and shielded by impenetrable shell companies. The legal battlefield was no longer just the local courthouse or the private arbitration suite. It was about to expand into a global forensic cat and mouse game, requiring the divorce attorney to hunt down ghost assets across international borders. The era of the hidden offshore fortune completely redefined the baseline competence required to practice high-net-worth family law in the United States. In previous decades, a spouse attempting to conceal wealth might simply transfer funds into a secret domestic bank account, purchase untraceable bearer bonds, or quietly buy real estate under a distant relative's name. These elementary tactics were relatively easy to dismantle through standard discovery requests, domestic subpoenas, and basic depositions. But as the global economy expanded, the ultra-wealthy gained access to a highly sophisticated, virtually impenetrable financial infrastructure, designed explicitly to shield capital from taxation and domestic litigation. The divorce attorney was suddenly forced to navigate a dizzying labyrinth of international law, battling sovereign nations that actively marketed themselves as legal black holes for marital assets. To understand the staggering complexity of this historical trend, we must dissect the architecture of the ultimate financial shield, which is the Offshore Asset Protection Trust. Jurisdictions such as the Cook Islands, Nevis, the Channel Islands, and the Cayman Islands essentially built their modern financial economies on a single aggressive legal premise. They fundamentally refused to recognize the jurisdiction or the judgments of United States family courts. If a wealthy spouse successfully liquidates $50 million and moves it into a Cook Islands trust months before a divorce petition is ever filed, An American judge can issue as many legally binding orders as they want, demanding the immediate return of that capital. The offshore trustee, sitting thousands of miles away, will simply ignore those orders. The American divorce attorney cannot merely file a standard motion to seize those funds. They must essentially wage an exhausting, multi-jurisdictional legal campaign that tests the very limits of international treaties. Imagine if a highly successful commercial real estate developer named Thomas, living in the United States in the current year 2026, initiates a sudden divorce against his wife of 15 years, Emily. During the mandatory financial disclosure period, Emily's legal team notices a terrifying discrepancy. Tens of millions of dollars in commercial lease revenue have completely vanished from Thomas's domestic ledgers over the past 36 months. Step 1 of the legal counterattack requires Emily's attorney to retain a highly specialized forensic accounting firm to trace the digital footprint of the missing capital. Step 2 reveals that the funds were systematically wire transferred in fragmented amounts into a domestic limited liability company formed in Delaware, a state notoriously known for allowing extreme corporate anonymity. Step 3 involves launching a massive legal offensive to pierce that initial corporate veil, only to discover that the Delaware entity is entirely owned by an anonymous holding company, registered in the British Virgin Islands. Step 4, the most agonizing and legally complex phase, reveals through international discovery that the holding company is ultimately controlled by an irrevocable trust established in Nevis, completely outside the reach of the American judiciary. In this precise scenario, Emily's attorney faces a monumental tactical crisis. They cannot successfully subpoena the offshore bank. The Nevisian trustee is legally bound by their local laws to withhold the funds from any foreign creditor, including a divorcing American spouse. Therefore, the elite divorce attorney must pivot to an entirely different, incredibly aggressive legal mechanism, known as the doctrine of impossibility and civil contempt. Instead of wasting millions in legal fees chasing the money overseas, the attorney attacks the spouse domestically. The attorney files an emergency motion arguing that Thomas intentionally and fraudulently transferred the marital funds to deliberately impoverish the marital estate. If the American Family Court judge agrees with this assessment, they can legally order Thomas to repatriate the funds immediately. If Thomas stands in court and claims he no longer has legal control over the irrevocable trust, and therefore it is impossible for him to retrieve the money, the judge has a terrifying ultimate weapon. The judge can hold Thomas in civil contempt and have him incarcerated in a county jail indefinitely until he miraculously finds a way to compel the offshore trustee to wire the money back to the United States. This intense legal brinkmanship turns the modern divorce attorney into a high-stakes psychological interrogator, using the explicit threat of physical incarceration to crack open international financial vaults. But the offshore trust was merely the first major evolution in the history of hidden marital wealth. The modern divorce attorney is currently fighting an even more invisible, technologically terrifying enemy. The historical trend of wealth obfuscation has violently collided with the explosion of decentralized finance and cryptocurrency. In the past, even the most complex offshore transactions left a digital paper trail monitored by central banking authorities and clearinghouses. Today, a financially sophisticated spouse can easily convert the entirety of their liquid marital estate into Bitcoin, Ethereum, or privacy-focused coins like Monero. They can then transfer those assets into a self-custodied, offline hardware wallet, essentially carrying tens of millions of dollars of marital wealth across international borders on an encrypted device the size of a thumb drive. This massive technological leap created an absolute blind spot in traditional family law. How exactly does a divorce attorney litigate a financial asset that they cannot even see, and that is not held by any central bank? They must instantly become digital forensic investigators. Step 1 involves issuing exhaustively precise discovery requests specifically targeting digital trails. This means demanding full access to scrutinized internet browser histories for logins to cryptocurrency exchanges, analyzing decades of credit card and bank statements for initial fiat purchases of digital assets, and subpoenaing personal email records to locate two-factor authentication receipts or welcome emails from trading platforms. Step 2 requires the attorney to draft specialized legal demands directly to major centralized cryptocurrency exchanges operating within U.S. jurisdiction, legally forcing them to freeze any trading accounts or custodial wallets associated with the spouse. But if the spouse is highly sophisticated and has already moved the assets off the exchange and into an anonymous cold wallet, the attorney must escalate to Step 3. They must retain elite blockchain intelligence analysts. These specialists utilize incredibly advanced algorithmic tracking software to map the public ledger. They follow the dizzying web of transactions, wallet addresses, smart contracts, and cross-chain bridges to mathematically prove to a judge that the spouse is the true, undeniable owner of the hidden digital funds. The potential outcomes of these high-stakes digital forensic battles are entirely binary and incredibly volatile. Either the attorney successfully traces the blockchain, proves ownership, and secures a massive equitable distribution of the digital wealth, or the concealing spouse simply looks the judge in the eye and claims they forgot their cryptographic seed phrase. By claiming the password is lost, they argue the digital assets are permanently locked in cyberspace and completely inaccessible, effectively attempting to erase a massive portion of the marital estate from the negotiation table. The attorney must then aggressively convince the judge that this sudden amnesia is a calculated, provable fraud. They must ask the court to disproportionately award the remaining physical assets, such as real estate or business equity, entirely to their client to offset the stolen digital wealth. This requires the attorney to fundamentally educate a judiciary that is often decades behind the current technological reality, completely transforming the traditional family courtroom into a highly technical masterclass on cryptographic hashing, decentralized ledgers, and digital security protocols. The sheer astronomical financial cost and the existential psychological risk of fighting these global forensic wars eventually led the wealthiest segments of American society to a stark, highly pragmatic realization. Engaging in unrestricted financial warfare over assets during a dissolution is a fundamentally inefficient, catastrophic destruction of capital. The hundreds of thousands or even millions of dollars in legal fees required to hunt down offshore trusts, hire blockchain analysts, and untangle shell companies can easily and rapidly bankrupt both parties involved. To avoid this mutually assured financial destruction, the elite class began desperately seeking a legal mechanism to completely bypass the unpredictable jurisdiction of the family court before the marriage even began. They demanded a legal instrument so structurally impenetrable, so perfectly drafted, that it would instantly neutralize any future forensic warfare and legally bar a spouse from ever demanding discovery. This massive societal demand forced the divorce attorney to evolve once again, transitioning from a retroactive adversarial litigator into a proactive, highly clinical architect of preemptive marital contracts, setting the absolute stage for the most heavily debated, legally binding, and fiercely negotiated legal document in modern American society. This document is the prenuptial agreement. To comprehend how radically this single piece of paper transformed the American legal landscape, we must first understand its deeply controversial history. For the vast majority of United States history, a contract that dictated the financial terms of a hypothetical future divorce was considered entirely void and legally unenforceable. The historical trends of 19th and early 20th century jurisprudence reveal a judiciary that viewed prenuptial agreements with absolute hostility. Judges operated under a strict legal theory that these contracts violated fundamental public policy because they inherently encouraged the breakdown of the marital union. The state believed that if you made it financially predictable and economically safe to dissolve a marriage, citizens would simply abandon the institution at the first sign of difficulty. Therefore, early divorce attorneys were effectively paralyzed. They could not proactively protect their wealthy clients because the courts explicitly refused to recognize the validity of their contractual architecture. This rigid judicial blockade remained completely impassable until a seismic shift occurred in the early 1970s, fundamentally altering the trajectory of family law. State Supreme Courts, beginning with a landmark case study in Florida, finally acknowledged the changing societal realities of modern marriage. They ruled that adults possess the fundamental right to contractually predetermine their own financial destinies, completely bypassing the default property division laws of the state. This single legal pivot birthed an entirely new, highly lucrative subspecialty within the legal profession. The elite divorce attorney suddenly evolved from a reactive battlefield litigator into a proactive corporate transactional engineer. Their primary directive was no longer to fight over the wreckage of a destroyed partnership, but to meticulously draft a legally bulletproof shield designed to completely immunize their client from the very jurisdiction of the family court system. Imagine if a highly successful biotechnology entrepreneur named Marcus, living in the United States in the current year 2026, is preparing to marry an independent art curator named Elena. Marcus has spent the last decade building a company valued at hundreds of millions of dollars, complete with complex venture capital funding, vesting stock options, and massive intellectual property portfolios. If Marcus and Elena simply walk down the aisle and sign a marriage license, they are unknowingly entering into a massive, state-mandated financial contract. If they live in a community property jurisdiction, Elena automatically gains a 50% legal interest in any wealth or intellectual property Marcus generates from the exact moment they say their vows. To prevent this vast automatic wealth transfer, Marcus must retain an attorney to execute a precise, highly strategic contractual severance before the marriage even begins. The creation of a modern prenuptial agreement is not a simple drafting exercise. It is a high-stakes legal tightrope walk. To ensure the contract survives a potential attack in court a decade later, the attorney must follow an exhaustive, step-by-step procedural methodology. Step 1 is the absolute elimination of procedural unconscionability, which is the legal term for extreme unfairness in how the contract was signed. The attorney must ensure a strict timeline. If the document is presented to Elena on the literal eve of the wedding, while caterers are being paid and guests are arriving, her future attorney will easily invalidate the contract by claiming she signed it under extreme psychological duress. To construct an impenetrable defense, the drafting attorney will mandate that the negotiations occur months in advance, completely separating the legal transaction from the emotional pressure of the wedding ceremony. Step 2 requires the execution of absolute, granular financial transparency. This is historically the precise point where the most aggressively drafted prenuptial agreements catastrophically fail in court. If Marcus attempts to hide a single offshore bank account, heavily obscure the true valuation of his biotechnology firm, or intentionally undervalue a piece of commercial real estate, he hands Elena's future attorney a loaded weapon. A prenuptial agreement is a contract based entirely on informed consent. If Elena does not have a mathematically perfect picture of the wealth she is contractually waiving her rights to, the waiver is fundamentally fraudulent. Therefore, the modern attorney must compel their own client to submit to a voluntary forensic accounting audit, attaching hundreds of pages of tax returns, corporate ledgers, and certified property appraisals to the back of the agreement to prove complete and total disclosure. Step 3 is the mandatory deployment of independent legal counsel. The attorney representing Marcus is ethically prohibited from advising Elena, and any attempt to do so creates a fatal conflict of interest. For the contract to be legally viable, Elena must retain her own fiercely competent, independent divorce attorney to systematically analyze the document, challenge its terms, and negotiate concessions. The dual attorney requirement ensures that the state cannot later claim that a wealthy, sophisticated spouse exploited a legally illiterate partner. The two attorneys will engage in weeks of intense, highly clinical negotiations, exchanging red-line drafts that argue over the precise legal definitions of separate property, joint accounts, and the specific formulas used to calculate future spousal support. As we analyze the modern historical trends of these negotiations, we see that the prenuptial agreement has mutated far beyond the simple protection of physical real estate and bank accounts. Elite attorneys are now routinely drafting highly complex behavioral modifiers, known as lifestyle clauses. Because the United States transitioned into a no-fault divorce system, the state no longer punishes a spouse for adultery or cruelty. To circumvent this, attorneys legally resurrect the concept of fault by embedding financial penalties directly into the contract. They draft strict infidelity clauses that clearly state if one spouse is proven to have engaged in an extramarital affair, their potential outcomes in the financial settlement are instantly reduced by millions of dollars. In the year 2026, attorneys are meticulously drafting social media non-disclosure agreements directly into the prenuptial contract, legally terrifying a spouse into absolute silence. If the marriage dissolves, the contract strictly prohibits either party from discussing the relationship on podcasts, posting about it on social platforms, or writing tell-all memoirs, with massive mathematically defined financial damages triggered by a single unauthorized post. The divorce attorney also builds dynamic, living mechanisms into the contract known as escalator clauses. They understand that a marriage is a long-term, evolving economic partnership. To prevent a judge from eventually throwing out a decades-old contract for being substantively unconscionable, the attorney drafts a phased payout system. For every 5 years the marriage successfully survives, the less wealthy spouse is contractually guaranteed a larger lump sum payment or a higher percentage of the estate upon dissolution. This legal architecture is designed to reward longevity, while simultaneously capping the maximum financial exposure of the wealthier spouse. It is a brilliant, cold, and highly calculated application of risk management to human emotion. The psychological toll of this entire process is profound. The modern divorce attorney is forced to sit across a mahogany conference table from two people who are deeply in love and legally force them to systematically visualize, debate, and financially quantify the absolute worst-case scenario of their impending union. The attorney must act as a grim architect of a hypothetical collapse, transforming the romantic ideal of an unconditional lifelong partnership into a heavily structured, conditional corporate merger. They are engineering a peace treaty for a war that has not yet begun, hoping that the sheer legal brutality of the document will serve as an ultimate deterrent to future litigation. But what happens when the legal architecture is perfectly drafted, the assets are securely shielded behind international trusts and airtight prenuptial agreements, yet the human element completely shatters anyway? When all the financial mechanisms have been exhaustively deployed and the emotional devastation is absolute, we must look at the final, overarching reality of this entire legal machinery and question what this centuries-long evolution has truly built for the modern American family. To answer this profound question, we must examine the stark, dual reality that exists within the United States legal system in the year 2026. The centuries of evolution we have documented, from the staging of hotel room infidelities to the aggressive tracing of offshore cryptocurrency wallets, constructed an incredibly sophisticated, virtually impenetrable legal fortress for the ultra-wealthy. However, this exact same historical evolution created a catastrophic systemic failure for the other 99% of the American public. By successfully transforming family law into an arena of exhausting financial warfare, complex psychological evaluations, and endless digital discovery, the elite divorce attorney inadvertently priced the average citizen entirely out of the justice system. We are currently witnessing one of the most alarming historical trends in modern jurisprudence, which is the massive, uncontrollable explosion of pro se litigation. Pro se is a Latin term meaning for oneself, indicating that a citizen is attempting to navigate the complex machinery of the court without retaining professional legal counsel. Decades ago, stepping into a family courtroom without an attorney was a statistical anomaly. Today, in family courts across the country, massive majorities of dissolution cases feature at least one, and often both, parties acting entirely without legal representation. This is not a cultural choice. It is an economic mandate. Because the historical trajectory of the divorce attorney forced them to become forensic accountants, psychological cross-examiners, and constitutional scholars, the standard hourly billing rate required to sustain that level of expertise became completely detached from the median American income. Let us deeply analyze and imagine if scenario to understand the brutal mechanics of this access to justice crisis. Imagine if a middle-class couple named Kevin and Rachel, living in the United States today in 2026, decide to end their 12-year marriage. They own a modest suburban home with a fluctuating mortgage rate, they share 2 children, and they both possess standard retirement accounts. They do not have international holding companies or complex stock options, but their financial lives are deeply intertwined. When Kevin attempts to retain a traditional, full-service divorce attorney, he is informed that a standard retainer fee simply to initiate the discovery process will consume his entire life savings. Faced with mutually assured economic destruction before the trial even begins, Kevin and Rachel are forced to proceed pro se. The potential outcomes of this unrepresented litigation are frequently devastating. The modern family court was explicitly designed by lawyers for lawyers. It speaks a highly specialized dialect of civil procedure that is actively hostile to the uneducated citizen. Step 1 for Kevin and Rachel involves navigating a labyrinth of mandatory state-specific financial affidavits. Because they lack an attorney to clinically audit these forms, Rachel accidentally miscalculates the tax basis of a shared mutual fund. Step 2 brings them into a heavily mandated mediation session. Without a divorce attorney acting as a psychological shield and a strategic negotiator, the mediation devolves into a purely emotional shouting match over perceived past grievances, completely ignoring the mathematical reality of their retirement division. Step 3 forces them to stand before a deeply exhausted, overbooked family court judge. When Kevin attempts to introduce a crucial email as evidence of a parenting dispute, he fails to follow the rigid, historically entrenched rules of hearsay and evidence authentication. The judge is legally forbidden from acting as his attorney and must exclude the evidence entirely. The resulting court order, drafted without professional legal oversight, routinely contains catastrophic structural errors, triggering massive unforeseen tax liabilities and creating unworkable, highly rigid custody schedules that will inevitably drag the family back into court years later. Recognizing that the traditional full-service model of representation was actively failing the majority of the public, the legal profession was forced to undergo one final, radical structural evolution. The modern divorce attorney of 2026 is aggressively dismantling their own historical business model, unbundling their services to survive in a fractured economic landscape. Unbundled legal services, also known as limited scope representation, completely abandon the concept of the attorney as the supreme commander of the entire case. Instead, the attorney acts as a highly specialized legal mercenary, hired for isolated surgical strikes. If Kevin realizes he is completely incapable of cross-examining a witness during his upcoming pro-se custody hearing, he can now hire an unbundled divorce attorney exclusively for those 2 hours of courtroom litigation. He does not pay a massive retainer. He pays a flat, predefined fee for a singular task. Step 1 of this modern arrangement requires Kevin to sign a highly specific, extremely narrow representation agreement, legally isolating the attorney from any malpractice liability regarding the rest of the case. Step 2 involves the attorney stepping into the courtroom, executing the cross-examination with surgical precision, and then immediately filing a notice of withdrawal, stepping back out of the case the exact minute the hearing concludes. This historical trend is fundamentally redefining the psychological relationship between the attorney and the client. The lawyer is no longer a trusted, long-term confidant guiding a family through a multi-year transition. They are a transient technical operator, utilizing their historical mastery of the rules of evidence as a commodified, on-demand service. But the absolute final stage of this documentary masterclass involves an evolutionary leap that is actively threatening to replace the divorce attorney altogether. We must examine the aggressive, deeply disruptive integration of generative artificial intelligence into family law. The historical role of the junior associate attorney, whose entire career was built upon spending hundreds of billable hours reading through thousands of pages of marital bank statements to find hidden transactions, has been virtually eradicated. The deployment of legal artificial intelligence requires a terrifyingly fast step-by-step execution. Step 1 involves a sophisticated legal firm taking 10 years of an opposing spouse's raw, unorganized financial data, including credit card statements, tax returns, and investment portfolios, and uploading it entirely into a secure proprietary language model. Step 2 requires the lead divorce attorney to simply prompt the artificial intelligence to conduct a forensic lifestyle analysis. In a matter of seconds, the artificial intelligence cross-references every single transaction, identifying hidden patterns of dissipation, flagging undisclosed cash withdrawals, and automatically generating a fully formatted, legally compliant spreadsheet detailing exactly how much marital money was wasted on an extramarital affair. Step 3 sees the artificial intelligence actively drafting the highly complex legal interrogatories and requests for production, perfectly citing the most recent state Supreme Court precedents. The modern divorce attorney is rapidly transitioning from an exhaustive legal researcher into an executive editor of machine-generated strategies. This technological revolution presents wildly divergent potential outcomes for the American public. On one hand, legal artificial intelligence holds the profound potential to finally democratize the legal system, drastically lowering the cost of generating complex legal documents and giving pro-se litigants like Kevin and Rachel access to sophisticated, algorithmically generated legal guidance. On the other hand, it threatens to strip the final remnants of human empathy and nuanced judgment from a process that is fundamentally, deeply human. When we look back across the vast timeline of American jurisprudence, from the rigid, deeply religious courts of the Massachusetts Bay Colony in 1643 to the algorithmic, blockchain-tracing legal tech centers of 2026, the historical role of the divorce attorney serves as a perfect, uncompromising mirror of American society itself. They began as legal pariahs, architects of necessary fictions forced to orchestrate staged adultery in cheap hotel rooms just to help citizens escape the suffocating grip of English common law. They evolved into aggressive political lobbyists during the era of legislative divorce, then into high-stakes constitutional gamblers boarding trains to Reno to secure migratory decrees. When the no-fault revolution shattered the requirement of moral blame, they became elite financial tacticians, valuing human intelligence and medical degrees as tradable commodities. They navigated the devastating psychological warfare of the best interests of the child standard, ultimately retreating behind the locked doors of private arbitration to protect the empires of the ultra-wealthy from the brutal transparency of the public docket. The divorce attorney is not merely a navigator of the law. They are the essential, highly adaptable technicians of human failure. They operate at the exact intersection where our highest romantic ideals violently collide with our most fundamental economic realities. They exist because society demands the absolute freedom to enter into the most complex financial and emotional partnership imaginable, while simultaneously demanding a legally binding escape hatch when that partnership collapses. As long as the institution of marriage remains a legally recognized economic contract, the divorce attorney will continue to evolve, standing as the ultimate arbiter of how wealth, power, and family are systematically dismantled and rebuilt. But as we close this exhaustive investigation into the machinery of severed partnerships, a massive, entirely different legal question emerges from the shadows. If the divorce attorney manages the contractual dissolution of the living, who controls the vast, incredibly lucrative legal warfare that erupts when a multi-million-dollar estate is suddenly severed not by a judge, but by death itself? We will uncover the deeply secretive, historically brutal world of the probate attorney and the legal mechanics of inheritance in our next documentary series.